Hello friends, I am B.N. Agarwal, ex-Chief General Manager, Steel Authority of India Limited, Bhilai Steel Plant, Bhilai. I am again back on the same issue of pension on higher wages. We all know that almost 2.5 months back, a circular has been issued by EPFO on dated 18th January 2025 of this year, whereby almost all the exempted trusts, mainly pertaining to public sector undertakings, have been rejected by concerned EPFO, citing the trust rules, internal trust rules, limiting the ceiling wages to rupees 6,500 or rupees 15,000, and also relying on the EPFO circular dated 18th January 2025. Now, in today's discussion, I will limit to only on this circular, 18th January circular, wherein we are concerned on clarification number 2 of the said circular. Now, what I could examine is that this circular has 3 elements in it. One is that the cases are to be determined on the basis of prevalent trust rules of the exempted establishments. Circular also speaks that determination of POHW for such exempted establishment is to be done on the basis of directions of the Apex Court in Sunil Kumar's judgment, and a cut-off date has been decided in the said circular, that is, if any amendment to the trust rules are carried out post decisions in Sunil Kumar case dated 4/11/2022, then such applications are not to be considered. Now, I am dividing today's video. Is a specific purpose why this video is today. That is trust rule, and second is Supreme Court judgment and the cut-off date as decided by EPFO. Now, coming to the trust rule, we all are aware that exemption has been given to these exempted trusts for running and maintaining the provident fund and not the pension fund. We all are aware in 2017 also, after R.C. Gupta's judgment, a circular has been issued dated 31st May 2017 by the EPFO itself, wherein at point number 5 it has been said that in the case of exempted establishment, the provident fund and pension funds are managed by separate legal entities. The provident fund of the employees of the exempted establishments are managed by exempted trust, and pension fund is managed by EPFO. This is what is our point, is that we are not managing the pension fund. Now, we all are aware that the employee pension scheme has come into being in the year 1995. A notification has been issued by Government of India on 16/11/1995. A relevant para for us is para 3, sub para 2 and proviso thereto. The initial ceiling was fixed at rupees 5,000 for the purpose of contribution to pension fund. Employer shares and 8.33% of the employer share was required to be contributed to the pension fund, wherein it has been specifically mentioned in proviso to the notification, para 3, sub para 2 and its proviso, that provided that where the pay of the member exceeds rupees 5,000 per month, the contribution payable by the employer be limited to the amount payable on his pay of rupees 5,000 only. This is very important. What all the trusts have been following was this only. 8.33% of 5,000 rupees per month, that is around 417 rupees per month, was required to be transferred are paid to the pension fund maintained by EPFO. I am also told in some of the RPFCs, particularly in South region, a specific direction has been issued by RPFC to this effect, wherein they have categorically written to the trust that contribution may be restricted on a maximum salary of 5,000 rupees per month, basic plus DA plus retaining allowance. So this kind of directions have been issued by RPFC and respective regions. Now we all are aware that this 5,000 ceiling has been raised to 6,500 rupees in June 2001, that is more precisely 1st June 2001 by a separate notification. At that time also, immediately after issuance of the notification, a circular has been issued by EPFO on 6th June 2001, wherein they have categorically written that they have written to, in fact, to RPFCs of the various regions of the countries, wherein they have written like this, that you are requested to take further follow-up action and ensure compliance from all the establishments immediately. That is, see that contribution to pension fund is restricted to 6,500 rupees per month only, 8.33% of 6,500 rupees per month. That is around 541 rupees per month precisely. Now comes the other instructions by Regional Provident Fund Commissioner and the EPFO from time to time. We all are aware that EPFO is a highly system-oriented organization. They have issued, handbook. They have issued model PF rule. They have issued exemption manual. They have issued pension manual from time to time. Now, in model PF rule, which they circulated precisely sometime in 2001, I believe, they have, given a total, replica of what the trust rule should look like, wherein 6,500 ceiling wages has also been mentioned in the same model PF rule. Now, in 2007, because this is relevant, in 2007, sometime towards the end of 2007, they have issued another circular, this circular by EPFO, wherein they have written that model PF rule approved earlier are to serve as a guide to the employers in framing of the PF rule of their establishment. It is, however, not mandatory to adopt them verbatim where an employer decides to frame PF rules incorporating some greater benefits than those offered under the provisions of EPF scheme 1952, the same shall be quite acceptable. See, it is natural that most of the trusts are having same language, and that language has flown from model PF rule only. The trust rule and the internal trust rule, particularly contribution to pension fund, employer share, is nothing but a verbatim adoption, or we can say a mirror image of model PF rule. I was telling that ceiling was raised to 6,500, then it was raised to 15,000. Now this 5,000, 6,500 and 15,000, from different point in time, either it was not mentioned in the trust rule or it was mentioned at a very later date. But the compliance was there at all times according to the government notifications and circulars and the instructions from time to time. There are certain exempted trusts wherein nothing has been mentioned in the trust rule. No 6,500 or 15,000 or 5,000. therein also either the cases have been rejected or I understand in some cases are being accepted, demand letters are being issued and revised PPOs are also issued. Even in some of the trusts, initially for a long time, demand letters were issued, PPOs were issued, but then at a later date they found that these cases can be rejected to save their face in other RPFCs where the same cases have been rejected. Now, very rightly said that two wrongs don't make a right, but that is what is being done. One more thing, that trust rule had either a reference of ceiling wages or no reference of ceiling wages, but the existing PPOs had a reference of 5,000 rupees, 6,500 rupees or 15,000 rupees as the case may be. Even the wages as on the date of exit in most of the cases written as 15,000, because we are talking about post 2014 58 years of age cases. So that is coming from where? Obviously it is coming from the para 27AA condition 10 of EPF scheme 1952, which mandates that any beneficial scheme need to be applied immediately and automatically without waiting for a formal amendment in the trust rule. And this has been confirmed also through various RTIs by the department. In fact, they have taken out and carved out ceiling wages, but they have totally forgotten the safeguard provisions available in the trust rule. In almost all the trust rule, wherever rejections have been done, a very categorical safeguard provisions are also available, mostly at the end of the trust rule, that if any provisions of this rule is less beneficial than corresponding provisions of the EPF and MP Act and the EPF scheme 1952 framed thereunder, the latter provisions shall prevail, mutatis mutandis. In fact, this language is also coming from model PF rules, but that is not being considered by the ROs in the country. In some of the RTI also, they have agreed that internal trust rule will not prevail upon and supersede the EPF Act and schemes thereunder. Now, under this background, not taking much time on trust rule, because trust rule, if there is a compliance of 5,000 rupees or 6,500 rupees or 15,000 rupees, as the case may be, is being treated as non-compliance perhaps. No trust has written any other language than these three amounts of 5,000, 6,500 and 15,000. If trust rules are superseding, then perhaps the employer would have written a willful amount of 50,000 rupees or 1 lakh rupees for the purpose of employer share contribution to pension fund. Now, coming to Supreme Court judgment and the cut-off date as mentioned in 18th circular. Now, two vital judgments, landmark judgments I should say, 2 judges bench and 3 judges larger bench, Honorable Supreme Court has already held in October 2016 R.C. Gupta's judgment. I will read out one para 7. The said dates are not cut-off dates to determine the eligibility of the employee to indicate their option under proviso to class 11.3 of the pension scheme. A beneficial scheme, in our considered view, ought not to be allowed to be defeated by reference to a cut-off date, particularly in a situation where the employer had deposited 12% of the actual salary and not 12% of the ceiling limit of 5,000 or 6,000 per month, as the case may be. Obviously, when we talk about 12%, it has to be 12% of the actual salary. Pension fund contribution is always on 8.33% of the ceiling wages or higher wages, whatever. Now, in Sunil Kumar judgment, the next judgment, an important judgment, para 17, it was held in case of R.C. Gupta dealing with pre-2014 position. The dates or the time limit specified in class 11.3 of the pension scheme were not cut-off date. The said time limit determined the eligibility of the employer and employee to exercise their option under the proviso to the said para. It was also observed in the said judgment that a beneficial scheme ought not to be allowed to be defeated by reference to a cut-off date. We all know para 38 is one of the most important para for exempted trust. I will not repeat that para 38, but para 39 is very important. Para 39, perhaps in my opinion, out of the 44 paras in Sunil Kumar's judgment, is the only para which talks about exempted establishment and exempted trust, something about this trust, other than para 38, of course. Para 39. One of the arguments against their inclusion into the scheme by exercising option is that corpus of the contribution for exempted establishments have been kept in separate coffers maintained by the trust created for such purpose and not with the authorities specified under the Act. This was the submission by the Union of India. Nothing has been mentioned about trust rule here. Honorable Court decides like this. Taking that fact into the account, we are of the view that in order to be entitled to the benefit of the pension fund, the employer and the employee simultaneously with exercising options in terms of the order of this court shall also have to give an undertaking of transferring the employer's contribution at the stipulated rate maintained by the trust, which shall be equivalent to and not lower than the sum which would have been transferable had such fund been maintained by the Provident Fund authorities. Such transfers shall take place immediately after exercise of such option within such period as may be directed by the administrator of the fund, administrator of the pension fund. Now, nothing has been mentioned about ceiling wages mentioned in the trust rule, limiting the contribution to pension fund and pension on higher wages because of this reason cannot be granted or whatever. Nothing has been written. Again in para 41, same thing, R.C. Gupta judgment has been reaffirmed by the Honorable Court. Para 43 is another important para. It again talks about the cut-off date. Now para 44, which is the operative part of the entire order of Honorable Supreme Court in 51 pages judgment. Para 44, sub-para 2. Amendment to the pension scheme brought about by the notification dated so and so shall apply to the employees of the exempted establishments in the same manner as the employees of their regular establishment. Transfer of the funds from the exempted establishment shall be in the manner as we have already directed. Then sub-para 4. The members of the scheme who did not exercise option as contemplated in the proviso to para 11.3 of the pension scheme as it was before the 2014 amendment would be entitled to exercise option under para 11.4 of the post amendment scheme. Their right to exercise option under before 1st September 2014 stands crystallized in the judgment of this court in the case of R.C. Gupta. The scheme as it stood before 1st September 2014 did not provide for any cut-off date, and thus those members shall be entitled to exercise option in terms of para 11.4 of the scheme as it stands at present. Their exercise of option shall be in the nature of joint option covering pre-amended para 11.3 as also the amended para 11.4 of the pension scheme. Now, this particular order has been given by the Honorable Supreme Court under Article 142 of the Constitution of India, which is the final authority. Supreme Court exercising a special power under the Article 142 has given, which is mandatory for all authorities to follow. Now, coming to the conclusion, I said there are three parts. One is trust rule, another is Sunil Kumar judgment, and third is amendment in the trust rule post 4/11/2022. Now, I have summarized these three things, issues like this. Internal PF rules referencing the ceiling wages of rupees 6,500 is only a compliance of EPS notifications and EPFO circulars issued from time to time. It also reflects mirror image and is a verbatim reproduction of model PF rule, EPS handbook, relevant notifications as circulated by the EPFO to the exempted trust. The trust has not carved out any imaginary ceiling wages on its own and has always contributed at the rate of 12% on the actual salary, which is eventually higher than the ceiling wages of rupees 6,500 per month. Subsequently, it was 15,000 rupees per month. Number 2. The EPFO circular dated 18th January 2025 also references compliances to the judgment of the Apex Court in Sunil Kumar's judgment for deciding the eligibility of higher pension to the exempted establishments. The Apex Court, in so many words, have allowed benefit to the exempted establishment for the members drawing salary beyond ceiling wages of rupees 6,500 per month, detailing the modus operandi of remittance of the funds back to the EPFO for entitlement to the pension on higher wages. Neither the EPFO raised any concern on any issues relating to internal PF trust rules before the Apex Court, nor did the Apex Court direct implication or obligation of ceiling wages in the internal PF trust rules for being eligible to the pension on higher wages. Rejection of pension on higher wages based on reference of ceiling wages in the internal PF trust rule is basically a blatant afterthought. Yes, it is a blatant afterthought on the part of the EPFO and related regional offices to deny the intended benefits or beneficial scheme as mandated by the Apex Court. And the last one, Honorable Apex Court in both the lead and landmark judgments have directed that a beneficial scheme ought not to be allowed to be defeated by reference to a cut-off date. Further, the Apex Court also allowed a further period of 4 months to exercise options required for availing pension on higher wages. The action of EPFO as per circular dated 18th January 2025 in rejecting the applications for amendment of the trust rule by determining the cut-off date post 4/11/2022. I am repeating, in rejecting the applications for amendment of the trust rule by determining the cut-off date post 4/11/2022 is grossly violative of the law laid down and mandate given by the Apex Court in 2 vital judgments. Now, court has already decided that a cut-off date cannot be decided by the EPFO. Now, here they have decided a cut-off date that if we have amended our trust rule after Sunil Kumar's judgment dated 4/11/2022, then the applications are not to be considered. So the entire 18th January circular is against the law laid down and the spirit of the Apex Code. This is what all I want to say. Now the option available with us is only to go to the court of law and litigate the matter. Thank you so much.